Welcome to Disputed, a Norton Rose Fulbright podcast. This episode is about securities enforcement. It is a tumultuous time for the capital markets, and securities regulators are as busy as ever. New financial products, read crypto, raise novel investor protection issues and call for scrutiny around what new business models do and how they should be regulated. New industries, read cannabis, invite in eager, unseasoned investors who may be exposed to a significant risk when representations about a business turn out to be misleading. And new legislation aims to revamp the way the OSC approaches regulation of the capital markets, including enforcement. To get the insider's perspective on all these developments, we welcome Jeff Kehoe to the podcast. Jeff is Director of Enforcement for the Ontario Securities Commission. He joined the OSC in 2016, having spent more than a decade running enforcement for the Investment Industry Regulatory Organization of Canada, or IIROC. And before that, he was a Crown Attorney and Crown Counsel with the Department of Justice. Joining Jeff is Linda Fuerst. Linda is one of the chairs of the Toronto Litigation Group at Norton Rose. She's a commercial litigator who focuses on securities litigation, class actions, and regulatory issues. Before going into private practice, Linda also worked as Senior Investigation Counsel with the Enforcement Branch of the OSC, where she also undertook a rotation with the SEC in Washington, D.C. Between them, Linda and Jeff have many decades of securities enforcement experience and a clear window into developments into this space. We were very grateful for the chance to speak with them, and we hope you enjoy our conversation. So, first of all, Jeff, Linda, thank you so much for joining the podcast. We really appreciate having you here.
Happy to be here.
Thank you so much.
So, Jeff, let me start with you, and I'm going to ask a question about the commission. You know, it goes without saying we're in the midst of a tumultuous time when it comes to all things, but obviously, you know, litigation and regulation and enforcement. What has been the impact, as far as you can tell, of the COVID pandemic on OSC enforcement?
No, that's a really good question and an important question. There's been some wonderful benefits, really, that have really developed out of the pandemic, and there have been some challenges. So initially, when the pandemic hit, we had to restructure sort of how we do both investigations and hearings. And what I mean by that is that we always did our examinations, as Linda knows, in person. And immediately we had to sort of essentially create sort of virtual investigation rooms where we were able to put documents to witnesses, documents to sort of those that are subject possibly to an investigation virtually. And at the same time, sort of try as best as possible to make the examination interview flow naturally as if it was in person. And that took some months. And once we sort of got into the groove of it, it's worked out really well so that we can now sort of do hybrid interviews where some people are in person, some people sort of are on the screen. So that has worked out well. The second challenge was the fact that our hearings were sort of adjourned for approximately 7 months. So from March until the fall, we had no hearings because the panel was really waiting to find out what sort of the impact of the I'll call it pandemic was going to have on sort of on having in-person hearings. As a result, we did have to create virtual hearings for the last year and a half, and that has been a wonderful thing. It's been a wonderful thing because we now can put on hearings that people from all across Ontario, all across Canada, in fact, all across the world can dial into. They can participate in a way that they couldn't in the past. So it's greater access to justice, and it really sort of aligns quite nicely with the open court principle. So we are hoping and anticipating that the virtual hearing room is going to continue even when it returns to in-person hearings.
Is the commission seeing, though, that a lot of people are in fact dialing into the hearings more so than would be attending physically if the hearing was conducted as it usually was at 20 Queen Street West in person?
That's a really good question. So we are tracking those stats, and for certain cases that is it is true. For example, crypto settlement agreements seem to attract people from around the world. And so we had a few settlement agreements where we had I'll call it significant numbers dial in to hear about the presentation of the settlement agreement and of what the sanctions were going to be. Other matters, as Linda said, it's still really akin to traditional in-person matters. There's less interest in some of I'll call it the more routine hearings.
Are there any changes in the trends or the types of matters then that are coming to the coming to the attention of the OSC?
So there are two parts to that question. And the first part is that we select our cases based on the priorities of the commission. So every year, the commission and the commissioners decides of what present the greatest risk to the capital market. So we use what's called a risk-based approach to identifying cases. And so we tailor our case assessment model to pick those cases that the commission has identified as a priority for a given year. For example, we are very, very interested in crypto, and we are doing a lot of those, but we are looking at ESG issues now. So we're starting to focus on that because that's a priority for the commission. We're looking at gatekeeper issues, and we are still focused on some of the more traditional types of violations, such as insider trading. The second part of my answer is that we also get a number of referrals and complaints from stakeholders, complainants, both in Ontario and really across Canada. And what we're seeing is that there is a huge spike in crypto related complaints. And that seems to be something that we anticipate is going to continue for the next few years. We also we're getting a lot of complaints about emerging I'll call it capital markets companies such as cannabis companies as well, in terms of valuation issues, in terms of I'll call it some challenges to some of their growth. And I think those are two things that will continue for the next few years.
Do you mind talking a bit more about what the crypto complaints look like specifically and where these complaints are coming from?
Yes, really good question. So there are a number of different types of crypto complaints. The most predominant complaint is fraud. And there are a number of websites around the world that advertise making a fortune on crypto, advertising how to teach you to invest in crypto. In fact, there are even dating sites that also talk about investing in crypto, if you can believe it. So the predominance of type of complaint is I gave a crypto platform my credit card and I lost $5,000. So that's the number one complaint. There are also some complaints about existing platforms in Canada, about service issues. I can't seem to get my money out of the platform, or I've been trying to do trading and it doesn't seem to be done fast enough. So those are other complaints as well.
Kind of interesting, Jeff, though, isn't it that, in terms of the crypto frauds, it's really kind of a variation on a theme of the old boiler rooms. It's kind of the same actors probably behind some of those frauds as we've seen in previous years operating securities boiler rooms.
Linda, that's absolutely right. So it's the fraudsters remain the same, but it's the products and the technology that's changed. And really that's it, because it's the same hype, it's the same type of promises that are made, and it's the same inducements, which is you can make a fortune overnight. And we all know that's not true. Anything that seems too good to be true is too good to be true. But people on a daily basis are induced to buy into it. But Linda's absolutely right. It resembles a number of the types of frauds that we've seen in the past.
So Linda, give us your perspective from the civil side on trends that you're seeing in private securities litigation.
Yeah, so I guess, class actions, the securities class actions in particular is the biggest thing. We saw an increase in the number of securities class actions a number of years ago. I think it was in 2021, matched the all-time high of 15 in 1 year in Canada, which is a high number for Canada compared to the US, and then a significant drop the following year. And one of the factors that seems to have contributed significantly to that trend, the uptick and then the decrease, were the cannabis class actions. As we know, there were quite a number of cannabis class actions that were commenced a few years ago, then that dropped off. And I think that accounts for that change. Another trend that we've seen in the past few years is the focus of class counsel on allegedly excess fees charged or being collected by financial institutions in the mutual fund space. And we've seen both fund manufacturers and discount brokers who sold mutual funds being the target of those class actions in a number of provinces. It's not just Ontario, it's also BC and Quebec. The trial of one fund manufacturer in a case in BC for having allegedly participated in something called closet indexing was decided recently in favor of the financial institution. But there are a number of class actions relating to similar practices that are still in the works, and we're going to see how those shake out over the next few years. And those cases are interesting because they involve some, novel issues about the application of trust law to mutual fund trustees. In Canada, mutual funds were set up as trusts. So some interesting issues that will be determined on a legal basis in those cases. And then just briefly, a couple of other trends we've noted is, we're seeing many more securities class actions being commenced in British Columbia as opposed to Ontario. And that appears to be as a result of changes to the Ontario Class Proceedings Act, which have changed the test for certification. There's also the Ragunanan principle that applies in Ontario that doesn't in BC. The result of that is that in BC, it's easier for a single plaintiff to bring an action against a bunch of defendants who engaged in the same kind of conduct than it is in Ontario. So those are some of the things that we're seeing right now.
So Jeff, what does the existence of that robust class action bar and securities civil litigation bar mean for enforcement? Does that let you train your focus on certain types of matters and give you some confidence that the civil system will provide relief for people who suffered losses to some extent? Does that free up your resources a bit to tackle other problems?
The answer to that question is complicated, but it's both yes and no. And first of all, yes, a robust class actions of, I'll call it, bar and sort of landscape is very, very important because civil remedies really sort of lend themselves to sort of all investors getting their money back. The challenge with an enforcement proceeding is that there may be 5,000 investors in a particular sort of product, in a particular sort of company, and enforcement may sort of interview 10, 20, or 30 of those investors. And if in fact we do a settlement agreement or a hearing, we may include 5 or 10 of them as part of our hearing process. The challenge is that if in fact we then sort of have a sanction hearing, we are not able to say, okay, the loss by all investors is X amount. That's simply sort of not something that is easily done in enforcement, because enforcement was never designed really to ensure that all investors get their money back within sort of the enforcement process. So we're very, very pleased that the class actions cases that are brought on behalf of investors are robust, and some of them are successful. That being said, the class actions are a great opportunity for enforcement in certain situations, for the enforcement arm of the OSC to get money to investors. And so where we can, we will use the existence of a class action to forward money to the class action. And we've done that in a few cases. I think a prominent example was the Home Capital case, where we used the class action to forward tens of millions of dollars to the investors and to the class action itself for disposition. The other challenge we have is if in fact we do take an action and we do try to get the money back to investors, as we did in something called market timing decades ago we did this. We then find that there were some investors that did not sort of know about the class about, I'll call it, the process, and did not know that they could get money back at the time. And so they've initiated their own class action, which is still ongoing. So it's a complicated area. So we applaud the existence of class actions. We utilize them where we can. and they do present challenges for us if, in fact, we take action, but we don't cover the territory of all investors.
I could just kind of pick up on another angle I think that comes out of that. It's kind of been interesting to see the interplay between the decisions that the civil courts are rendering in the secondary market securities class actions and the reliance of the courts on the developed jurisprudence that the OSC has relating to things like the definition of materiality and what constitutes a material change. And it's going to be interesting to see to what extent now that the commission may in fact rely on some of those cases emerging in the civil context when they're dealing with disclosure issues, and whether there's going to be mutual reliance on the decisions of the other.
And there's certainly going to be robust debate about that, and Linda's right. So we may see some civil concepts as about creeping into some enforcement cases down the road.
This might be slightly off topic, but something occurred to me as you were talking about the class actions, and you mentioned ESG issues earlier, as well as another trend that we're seeing. We recorded an episode on greenwashing claims last week and greenwashing litigation. And I'm just thinking some companies are increasingly facing action, potentially class actions, when it comes to engaging in greenwashing activities. Is that something that is coming onto the OSC's radar at all, nature of investigating greenwashing activity? And what would that look like in terms of this dynamic with class action activity when it comes to greenwashing?
So that's a really good question. And the idea of greenwashing is something that we take very seriously. Essentially, it's misleading disclosure. And that's how we would look at it in the context of securities regulation, is that you're representing, for example, that you're doing so many good things to protect the planet, and in fact you're not. And so if in fact we discover that you are misrepresenting us of what you are doing, then we will take action. And we are looking for those cases right now. It's early days. The existence of a class action sometimes can be a great referral for us. If in fact we see, let's say, a class action initiated and it's an allegation of greenwashing, we may investigate ourselves to see if in fact we can find an enforcement case out of that class action. And we've done that in the past.
I think it also speaks to an interesting question about the evolving role of the regulator and to what extent it is proactive or reactive. Do you think it is, particularly with the rise of ESG issues, do you think it is transitioning from a reactive role to a more proactive role?
In certain areas, we do have to be more proactive, and I think we are trying to be proactive. I think ESG, it's going to be a bit of a challenge to be as proactive as we would like right now. And the reason for that is the international standards for ESG are not quite settled yet. There are actually competing standards that are being developed around the world. And so it's a challenge for a regulator to say, well, you picked the wrong subset of standards. So I think we're going to take our guidance from both the internal experts at the OSC, our corporate finance department that is developing expertise around, let's say, greenwashing and appropriate standards in ESG itself before we really launch into a number of cases. But to answer your question, I really wish, I've got to be careful what I say because we're really just starting on ESG. But let me pivot to another area where we are trying to be much more proactive. And that's into I'll call it internet-based misconduct. And internet-based misconduct does not easily lend itself to traditional enforcement action. And the reason for that is if in fact the assets go from jurisdiction to jurisdiction, which they do, especially in the crypto space, it only takes one jurisdiction to tell us that they're not going to cooperate with us. That then renders the enforcement action difficult to complete. So as a matter of, I think, necessity, enforcement is now looking to international disruption to be more proactive. How do we stop the harm in its tracks? And so we're working with other regulators around the world to develop practices and principles around disruption. And we hope that really to arrive at a body of accepted protocols where we can be more proactive. And I would love that to expand into some other areas. of capital markets, because if you can stop the harm in its tracks, then sort of investors really get much more meaningful sort of investor protection.
Really an age-old problem, Jeff, isn't it? I mean, from my days at the commission many years ago, there were difficulties sometimes getting foreign regulators to assist OSC staff in investigating cross-border misconduct. And the smart bad guys out there know which jurisdictions to pick and to operate out of, because they know that certain regulators are going to be less cooperative in those kind of cross-border investigations. And I think that's why so much work was done in the past about developing memorandum of understanding and, IOSCO becoming the more robust international organization that it is now.
That's exactly right. And it even goes beyond assets. We've had recent examples where we can't even find the principals of an existing entity because they are scattered around the world, and there is no head office. There is no bricks and mortar of these entities, and as a result, it is very difficult to find the individuals that are in charge of these, I'll call it capital markets entities, whether it's crypto or others. But it's presenting problems for us. And like Linda said, the problem's already has always been there, but it's becoming increasingly more challenging to affect the traditional enforcement action because really of internet-based misconduct, internet-based capital raises, and the fact is that this next generation realizes we don't have to have a head office. I can be in Singapore, the CFO can be in Malta, and so the chief compliance officer in Canada.
And is this something that OSC enforcement is discussing with the RCMP and the criminal authorities as well? Because they face the same issue, don't they?
They do, and we have been in discussions with law enforcement, RCMP, other law enforcements, as well as our IOSCO members. We're going to have to, at one point, sometime down the road, really grapple with the collaboration that's needed to get the bad guys, so to speak.
Jeff, you mentioned the traditional securities enforcement action, but of course, your organization is undergoing considerable change as well right now. I mean, you've formed the Capital Markets Tribunal for adjudication of enforcement issues. There's a new board of directors whose roles and responsibilities have changed. There's a new office of the CEO. How is that impacting enforcement?
So we're not seeing really any, I'll call it demonstrable changes so far. The internal workings of the commission are different. They're very different, but enforcement has always enjoyed a little bit of a separation. And in the past, that was because of the actual structure of the commission itself. The commissioners were both tribunal, they were tribunal members, they were policy members, and they were the board. Now there is that separation. So internally, I'm able to talk more about what enforcement does because the commissioners are no longer tribunal members. But there's still that healthy separation between enforcement and what I'll call board governance. And as a result, there's really no changes so far. There's no changes really at the level of I'll call it the tribunal because it still functions in the same way that it did. It's just separated. There is that I'll call it acknowledgement that they are a completely separate tribunal. We are trying to work out new types of documents, new types of arrangements with them. And the biggest change, if anything, is that we now are very conscious of the fact that we will need to do everything that, let's say, requires reform with the bar. So Linda has to be at the table if, in fact, we want to change a document. We can't simply go like we did in the past where we'd have an internal discussion because that's really the way it was done because it was part of the commission. Now it's not. So we're going to in the future use the body known as SPAC, which is essentially some enforcement people from the commission side, as well as the bar, such as Linda, who will participate in discussions about how to run the tribunal process better.
So just picking up, Jeff, on what you just said about the new structure at the commission, I think, in general, Respondents Counsel, the private side of the bar, was reassured by the appointees to the new enforcement, or rather the new capital markets tribunal. They all seem to be well qualified. But I think, there is a concern that over time, some of the expertise that the former hearing panel members had, by virtue of the fact that they were also commissioners and involved in the making of policy and had a very sound understanding of securities law and practices, that could be lost. And as a result of that, there may be less expertise at the tribunal level as time goes on. And it was that expertise that led the courts originally to give so much deference to commission decisions. So I think that there is a potential impact in future, again, depending on the quality of the appointees going forward.
Okay, so we've talked about crypto trading, platform enforcement, activity enforcement, ESG trends, illicit internet activity. Linda, specifically, what more general trends can we expect to see in this space in the next year or so? What trends are you looking at most closely when it comes to OSC enforcement activity?
So I'm going to answer that both with respect to OSC enforcement activity and civil litigation, if that's okay. Obviously, there's a lot of economic disruption going on right now. We've got interest rates going up. We have the threat of a recession. And, typically and historically, when markets have dropped in Canada, investors tend to look for deep pockets to try to recover, investment losses. So, I think that the outcome of that is going to be, we're going to see a lot more investor complaints to the securities regulators. We're also going to see an uptick in civil litigation, and in particular in securities class actions over the coming months and, potentially years. So that's one trend I think that shouldn't be a surprise to anyone. Jeff spoke about an increase in the regulatory attention being paid to cryptocurrency. We're also seeing that on the civil side, and I know Andrew has had some experience with this himself, being involved in a number of civil crypto disputes. But I expect we're going to see that trend continuing. We've already seen courts being very active in terms of making things like Anton Pillar orders and Moreva injunctions in the context of cryptocurrency related disputes, issues relating to loss of tokens by investors. And I think that trend is just going to accelerate as cryptocurrency continues to be an evolving, financial instrument in the coming years.
Jeff said as well about the cannabis space, because it's a market where so much activity happens so quickly, so many people flooded in, and so many businesses are struggling now with, it seems like, every aspect of that business to be in. And so the level of scrutiny that's going to be applied to public statements made about how businesses are functioning and how investors are being treated at every level seems to me to be a continuing area of focus for regulators and for class action attorneys and for all types of disputes. So that's another clear one.
And then, finally, there was already reference to ESG and greenwashing and seeing, some expectation of increased regulatory action there. I know we have done a previous podcast about litigation arising out of that, but we do expect to see more civil litigation coming down the pipes in that area. Certainly, there's a lot of shareholder activism in the ESG space in Canada that our firm has been involved in. And I expect there's going to be more of that. This is an area that the insurers are paying very close attention to because it has obvious implications for their risks. So we are paying close attention to that. We expect that we're going to see a lot more of that. It's something that we're all getting ready to deal with. And obviously an area of concern for a lot of publicly traded companies out there as well.
So Jeff, Linda, thank you so much. I think we might invite you back to pick up on some of these trends and follow up on where things are in the future, but thanks for your time today.
Thank you very much.
Thank you so much, and I'd be happy to come back.
Thanks so much, Jeff. We really appreciate it.
We hope you enjoyed this episode of Disputed. If you'd like to find out more about this topic or how to contact our guests, please visit nortonrosefulbright.com/disputed. Also, if you have any questions, feedback, or topics that you'd like us to cover in a future episode, please do email us at disputed@nortonrosefulbright.com. And if you would like to hear more, please subscribe to Disputed on Apple Podcasts, Spotify, or wherever you get your podcasts.